All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. I am Judge Ferruia, and to my right is Judge Campbell. To my left is Judge McMurdy. And we are here for oral argument in our case number CV 22-0152, Almada Negrete versus Simonson. I know I butchered that. I apologize. As you may know, we record and live stream these proceedings, so please give your name and the name of your client when you begin. You have a maximum of 20 minutes per side, although you are not required to use all of that time. Just please know that the clocks there are for your convenience in keeping track of your time, but the clock time includes any time that you wish to reserve in rebuttal. It is your responsibility to reserve any time you want to reserve for rebuttal. Just please let us know, and we will try to be respectful of that request. Please keep in mind, we have read the briefing, we have studied the record, we have discussed this case in conference, and with that in mind, you may proceed, counsel.
May it please the court, my name is Mark Hawkins. I'm the attorney for Social Almada Negrete. I'm hoping to reserve some of my time for rebuttal. I'll tell you that now in case I forget later. If I do use all my 20 minutes and run out of time, that's fine as well. The thing I want to emphasize is that this is a case about Richard Simonson and whether the law in the state of Arizona respects the rights that Richard had while he was alive and the rights that his estate has after his death. I think one of the things that the trial court did in this case was to confuse the rights of Richard and his estate with the rights of his heir, Michael Simonson. And I think that was the critical error that led to the wrong decision about whether there's a right to a hearing and whether the petition to have a personal representative appointed or a special administrator should have been granted.
What does a hearing entail? When it says you have a right to a hearing, does that necessarily include a right to an evidentiary presentation? Or just being able to come to court and to talk to the judge?
In this case, it would have included a right to an evidentiary hearing.
Well, okay, let me stop you right there. So you say it's a right to an evidentiary hearing. But don't we, in almost every circumstance, give discretion to the trial court to determine whether or not there's been a colorable claim raised to have an evidentiary hearing?
I made that argument at one point and said the judge could he could appoint a special administrator. And whether he did the public fiduciary or he did social, he needed to appoint somebody. And that, I'm arguing today, was an affirmative responsibility for the court. This was not Social's case to bring to court and to see that justice was done. This is an onus upon the courts of the state to enforce the law. If the law says that there was a wrong committed against Richard.
Well, okay, I think we're doing ships passing in the night here. My question is more mundane. My question would be, if you say, I have a right to a hearing, and the judge says, well, what factual dispute do you want me to consider that would require evidence?
And the answer to that is, did Michael Chin, who was the employee of the ML defendants, Bank of America, Merrill Lynch, and Michael Chin, who is the employee of those organizations, Bank of America owns Merrill Lynch. There's a couple things. Did Michael Lynch, the conversation that Michael Chin had with Michael Simonson, after Michael Chin, who is the personal banker with a fiduciary duty to Richard Simonson, He was his personal banker. He was his financial advisor. He had the biggest financial duty possible to the decedent. And that was before his death. And there was a wrongful death. There was the check from Sochil or from Richard payable to Sochil was presented to Michael Chin. He saw it. He knew about it. I'm assuming all of these facts are correct.
So am I. That's why I'm asking you the question, is I'm not sure anybody's disputing a particular factual point. So you say I'm entitled to an evidentiary hearing, but we only grant evidentiary hearings if there's a factual dispute. And my understanding from the appellees is there is no factual dispute.
If that's the case, these facts look absolutely horrible for the banking institution involved. How could you have worse facts than somebody in a bank who is the personal fiduciary contact? And so what I'm saying, that actually is an argument, I would think, in our favor as to why the judge must have taken action. He could not simply say, I'm not going to hold a hearing, I'm not going to do anything about this. The hearing...
Mr. Hawkins, again, I think you're missing the point. If the court is accepting those facts as true, then your request for a hearing is, who cares? I'm accepting those as true. But then the court goes on to say, assuming they are true, legally, there is no error, right? Isn't that what he did?
Yeah, I don't think he did the right thing. It's just...
Well, okay, but that's a legal argument that has no bearing on whether or not you're entitled to a hearing because he accepted your facts as true.
Okay. When you're writing your opinion, you're going to be looking at the statutes and the rules involved. In those statutes, what we're asking you to do is to be looking carefully at a couple of statutes, and this is one of them. What is this? Is there a difference between a personal representative and a special administrator? The answer is yes, there is. But the special administrator is very close to the responsibilities of a personal administrator. The personal administrator has duties, or the personal representative, I'm sorry, that has the duties that are required to be part of they either have to be a creditor or they have to have to be the heir, the devotee, those kinds of things. And the special administrator, is there a possibility that a special administrator is a broader rubric than merely having a personal administrator or personal representative? In this case, Sochil was asking to be both the personal representative and the special administrator. Those were separate petitions. It was probably a mistake in hindsight from a standpoint of all these other claims. The amended complaint that was filed had other claims. Fraud, breach of fiduciary duty, and these other claims. And they were brought with a petition to remove the personal representative and to appoint Sochil. If you don't have a hearing, how is the judge going to proceed with appointing a public fiduciary, which he must, in order to fulfill his duties as required by the statutes, he must appoint, he has an affirmative duty to appoint a personal representative as the public fiduciary in that capacity if he finds that based on these facts there was a theft. He can't abdicate that duty to Sochil. He can't abdicate it to anybody. If you have DHS or DES or whoever it is and they report a crime, one of their workers, you have a hospice worker who reports a crime to DHS or DEA, and they have a vulnerable adult statute. There's a duty to report. So it goes to the guardian or conservator. It could even be a de facto guardian or conservator, and that person is supposed to bring a complaint or a petition, and that then has to go to the court. The buck stops with the judge. These are people are merely reporting to him, this is what happened in the facts in this case. A public fiduciary must be appointed. So if there was no duty to have a hearing, the judge erred in simply not appointing a public fiduciary without a hearing. But could he appoint a public fiduciary without a hearing? I don't think so. I don't think the statutes contemplated that, although it's possible they did. And that's something to look at very closely in the reading of the statutes, which I don't have them all memorized, not in front of me right now, but that's what I'm asking you to look at. If there was no duty for having a hearing, then wasn't there a duty, an affirmative duty by the court to do something? You can't say that the state of Arizona and our laws allow this kind of theft, which is the facts are accepted as theft, I take it, They're saying, yes, the Bank of America stole money from Richard Simonson. And yes, Michael Simonson stole not just $420,000, but $850,000 from his brother Richard. There were acts occurring both before and after Richard died. And the reason I'm talking about a vulnerable adult statute, I believe we're hearing this, if it's a matter of law, we're doing this de facto, de novo. And you all, we're asking you, please look at these issues. How could you have an $800,000 theft that doesn't go to the police department? Why? Because there's no personal representative, there's no special administrator. If Sochil goes to the police, he says, I'd like to make a complaint. They say, who are you? Well, I'm not a representative of the estate. Well, then let's let Michael Simonson go as personal representative and make a complaint against himself for theft to the police department. That's why it stops with the court. The court could not ignore this. The state of Arizona laws do not allow it. Our statutes were not designed that way. The vulnerable adult statute is harsh. And it applies here because you had a man who was within 6 days of his death, on his deathbed, can't get out of his hospice bed, who's writing a check to get his intention fulfilled. And his intention is to give away his money. He's going to give $420,000 to Sochil. He's going to give $450,000 to Sue Bosmer. And that's his intention. What does his brother have to say to do with it? They're saying he doesn't have a fiduciary duty until after he was appointed as heir. And there's an interesting twist to that, but the reality is he committed acts before Richard died because there's this conversation between Michael Chin, the personal banker, the man with a huge fiduciary duty on behalf of the banks involved. In a single bank, they're all the same one and they're owned by each other. If you have that kind of breach, that tremendous unethical behavior by a bank saying, we're not going to take your check. You know why, Richard? We're not going to take your check because we know you're in the hospital, you're dying of pancreatic cancer, you'll be dead within days. And Michael Chin knew all of this because he ends up showing up at the funeral within 24 hours of Richard's death. And he's telling Sochil at that, you can hire an attorney. You need to, my hands were tied, I had no choice. I had no choice were his words. Under those facts circumstances, how could the trial judge say, no, not only am I not going to appoint a hearing, and not only am I not going to hold a hearing, I'm not going to appoint a public fiduciary. How? Who is it? Is it the police duty or is it the trial court's duty? It is the trial court's duty. Is it the duty to report? Is it the duty of the DHS? No, it is the trial judge. All of this was placed before him. He cannot abdicate that responsibility. Whether he holds a hearing or not, he must appoint a public fiduciary to take care of this theft. You can't report to the police.
You keep saying theft, and I'm not really sure what it is you're talking about, to be honest with you.
There are multiple aspects.
I know factually what's going on. There were 2 checks that were written.
Yes.
One check was destroyed, and the other check, the bank notified the brother and said, there's something odd about this check, right?
Yes.
And the brother says, put a stop payment on it, right?
Yes.
Okay.
That's possibly, how would we know without a deposition or a hearing?
Well, isn't that the allegation? That the brother put a stop payment on the check.
You take it.
So how did the bank steal anything?
Okay, here's the theft occurs when you have a $2.3 million loan from Bank of America, which owns Merrill Lynch, and you have, and they're making this loan for $2.3 million with a guarantee, and the guarantor is Richard Simonson, the decedent, and it's before his death. So at the time that the bank is refusing, when Michael Chin knows about this personally, he went to the funeral with him. He knew about it, and he calls up Michael Simonson, and they have this discussion. The discussion is, look, we've got a guarantee from Richard Simonson, and he's got $870,000, and he's trying to give it away. I don't know how much was in his accounts. Even now, I haven't been able to I can't subpoena the records to even find out. But let's assume the worst case scenario for them, which is what we're supposed to do, the worst case scenario for them is that you have this conversation in which Michael Chin says, look, instead of calling Richard and saying, hey, you want me to cash this check?
Mr. Hawkins, we have a whole series of probate rules and statutes that address how to dispose of property upon one's death. And the reason we have that is to avoid situations like this. So you have somebody in the hospital dying of cancer, close to death, and in fact dies within 6 days of issuance of a check. Doesn't that kind of substantiate what the bank did? Was said, whoa up, wait a minute, let's figure out what's going on here. Is there testamentary capacity to make these gifts? Let's slow down and figure out what's going on. How is that a theft? Isn't that the fiduciary role the bank is supposed to play on behalf of the decedent?
If the banker, Michael Chin, has an evil state of mind, which is the facts that they've accepted, his state of mind is that if I cash this $420,000 check, I will lose the collateral value of the $420,000 that Richard is giving away.
That meant nothing to the banker. The banker did not receive much of a benefit from holding on to the check or dishonoring the check. I'm not exactly sure, and maybe you can convince me. What was the direct benefit that the banker received by not honoring the check? The retention of the $450,000 in his institution?
Yes, it's a big deal. If you have $420,000 that you loan to somebody and they have their parents sign for them.
That's not a personal loan. I mean, he didn't make a personal loan. And this is the bank loan, right?
He's the employee. Why are you distinguishing Michael Chin's state of mind from the bank? I don't understand the distinction there. They should be exactly the same. You're under our set of facts, you have Michael Chin having absolute knowledge that if he doesn't cash this check, then he will maintain the collateral. And under the conversion statute in the criminal code, you can steal money from somebody if you take their money for 6 days and stick it in your pocket and refuse to give it to them. That's theft. That's why.
Okay, hold on for a second. Let's say the converse happens, and Michael Chin cashes the check, gives the money to your client, and then is later sued by Michael Simonson because he says his uncle or his brother lacked testamentary capacity. So then he's in the converse kind of situation where he is given out the money and has nothing to retain, and now we have this issue about how he was a fiduciary to the decedent as well. He was in a lose-lose situation, was he not?
Yes, and he
And
absolutely
banks,
should
in
be.
most cases, will stop and hold the funds until they can get to the bottom of who's entitled to the money. Do they not?
I wouldn't. If you do that, you're doing the wrong thing. Here's why.
So you're saying that when I get a check and my bank says, we're not familiar with the person writing this check, we're going to hold the funds for 14 days to make sure the check clears, they've committed a theft on me?
This is a factual issue, and if we're going to have a hearing, we can answer this.
But we have to accept the premise that you are putting down, which is this was a theft by not releasing the funds. And I'm not there yet. I'm hoping that you can convince me that it, in fact, was a theft. So that's the part I'm hung up on.
Okay. And I'm saying you can't get there without a hearing and having the facts unless you assume the facts that I'm telling you are correct. And I believe they are, but how are we going to know without a deposition, without a hearing, without a motion to dismiss?
What I'm telling you is I'm assuming every fact that you have laid out is in fact correct.
Yes.
The conclusion you reach is what I'm struggling with. You conclude that the actions of the bank and the bankor in this circumstance equates to theft from the decedent. And I'm not there. Help me get there.
Okay. You've got a situation in which you could have criminal prosecution for an $800,000 theft, and the prosecutors would understand what's going on here. Because the theft is when you take, under the criminal statute, you take money, you put it in your pocket, and you say, I'm not going to give this to you. I know it's your money. This was money Richard deposited in this bank. He gave it into their hands, and they sat there and stuck it symbolically in their pocket.
But it's
Knowing what
intent
they were doing
to
and why they were
permanently
doing it.
deprive the person of the benefit of that item. So theft requires an intent to permanently deprive. The bank said, we're going to hold this for a minute and try and get to the bottom of what's going on here.
That's a factual issue as to what is their intent? Is it their intention to hold their collateral, which is our assertion, or is it their intention to protect themselves? That is precisely what we want to present to the trier of fact at a trial. Why did they do it? What was the motive? Why did Michael Chen, who had all of this knowledge, why did he take this money and proverbially stick it in his pocket for 6 days, knowing that the pay on death payee is Michael? So that's where the money's going to go. Is that permanent deprivation? Of course. Is it conversion under a criminal code just to take it for a couple minutes? If your intention is to steal the money, and that's the factual issue that we're dealing with.
You're trying to, I think you're conflating Michael Simonson's intent with the bank's intent. The bank has a vested interest in making sure they don't pay out money that the recipient is not entitled to. And so to hold that decision until they can get to the bottom of who is rightfully entitled to it is kind of their job.
No, it's a question of motive, and motive is a factual issue.
Okay.
Thank you, Mr. Hawkins. Mrs. Elm.
Good afternoon, Your Honors. Tina Ezel for the Simonson appellees. That would be Michael Simonson, who's here in the courtroom, his wife Cynthia, not this person, and also as the personal representative of the state. Can you hear me? Better.
I can hear you.
Okay, great. So the court, I did want to clarify something that Judge McMurdy requested or talked about with the appellant's lawyer. Nowhere in the allegations, the factual allegations that were presented by the appellant, was their assertion that Michael Simonson, either individually or as the PR or any of the Simonson appellees, put a stop payment on any check. The only factual allegation that was made by the appellant was that he got a phone call and he claimed not to know who Ms. Almada Negrete is. That's it. Not that there was a stop payment. I'm not sure it makes a difference, but I didn't want there to be a
Well, I thought the allegation was he got this and he said, I don't know who that is, so hold on to it or something to that effect.
I don't recall that being in the amended petition or any petition that he asked it to be stopped, just that he didn't know who that was. And by the way, I think it bears mentioning that some of the facts that appellant's lawyer was up here espousing today have never seen their way into any petition. These are conjecture. And even the ones that did make their way into an amended petition, Ms. Almada Negrete, I hope I'm saying her name correctly, stated she didn't actually have a basis for these facts. She was stating that she thought she might be able to get them, and she cited a rule that says that if you have a good faith belief for that you're going to be able to get certain facts, you can allege them. But these facts that we're taking as true don't actually have a factual basis. One of the things that I think...
But your client doesn't dispute that, in fact, the decedent wrote a check for a large amount of money, $420,000, with a contemporaneous note that indicated his intent to transfer that money to her.
My client does not dispute for purposes of these proceedings. We've never gotten to even answering the amended petition, but for purposes of what you have to address today, you have to take as true the factual allegations that...
Right. So, I mean, that's my point, is you haven't disputed it, so we're taking that as true.
So one of the things that Mr. Hawkins stated is that there's no way really to answer the questions of this panel pertaining to what the other facts that haven't been alleged are, because you were asking him questions about intent and what was what was Mr. Chin's, and he's not my client, but what was Mr. Chin's intent and what was Michael's intent. He says, there's no way for us to know unless you have an evidentiary hearing. But I would submit to you that there is a way that if he had wanted to present facts to the trial court to convince the trial court that the appellant met the threshold level to hold an evidentiary hearing, that he could have done any kind of discovery at all. I think he didn't because he knew it wouldn't have resulted in what he was hoping for, but no discovery was done. So
Did he request discovery?
I wasn't the attorney in the beginning of the case, but I don't recall any depositions of any kind of any person. I think we submitted some discovery requests over, but I wouldn't feel comfortable saying there wasn't any, but I don't remember any.
And there was a request for a hearing.
There was initially, well, are we talking about the personal representative or are we talking about the special administrator? So for the special administrator, the appellant stated there was no hearing necessary. However, the appellant did get a hearing by the court when she filed her separate request for a special administrator. The court got everybody together and talked about the whole situation. She also got a hearing on, and it's cited in the record, on the request to oust Mr. Simonson as the personal representative.
Well, it's an interesting argument to what's a hearing if you're not able to put on evidence. I'm assuming that when you request a hearing, well, I don't want to assume anything. When you ask for a hearing, are you asking for like a pretrial conference, or are you asking, say, Judge, I want to put on evidence? And you need to be more specific.
Well, I mean, I think that the way that the statutes that we've been talking about in this case are worded, they very carefully don't say that every person who makes assertions or allegations and every person who, I mean, that's what working with allegations is entitled to an evidentiary hearing. It gives the trial court more leeway to determine what type of hearing, and maybe even 2 hearings, will be necessary in a particular case. In this case, the court did hold hearings on these issues, did not determine that the factual allegations were worthy of granting the appellant a evidentiary hearing. I think that's really right because the trial judge is in the best position to judge all the cases that he or she is judging to determine whether the factual allegations merit a hearing. It's a lot like any other situation that we're confronted with. Judges can grant a hearing in their discretion. If they abuse their discretion, then of course we have an issue, but in this case we submit there's no abuse of discretion.
Well, and I don't mean to dominate, but based on this record, are you aware of any assertion where I want an evidentiary hearing? Judge, let me present my facts.
Certainly in the appellate briefs.
I know that.
I've seen it.
We call that waiver if you're only raising it in your appellate brief.
And that,
I'm asking, in the record, was there an assertion for an evidentiary hearing to present evidence?
I don't recall a separate request for an evidentiary hearing, but I do recall in the amended petition that there was a request for Mr. Simonson to be ousted and Ms. Almada Negrete to be substituted in, which under the statute would require a hearing. And I think that you can't put these people in these positions unless you have a hearing. So the way I interpret the statutes, and I think the courts of appeal as well so far, is that if you're going to oust a PR or if you're going to appoint a special administrator, then you're going to have an evidentiary hearing. But if you're not, because the facts don't rise to the level of warranting one, then you don't have to give an evidentiary hearing. So, and if I may?
Oh, please.
Okay. I think that's a really good segue. I have to leave 8 minutes for the bank's counsel by agreement. You know, I read the reply brief with a little bit of shock because for the very first time I saw allegations that had never been in the trial court level or in the opening brief where Ms. Almada Negrete says The court had a duty, almost as an advocate, to hold a hearing to investigate all the facts of this case to determine whether Mr. Simonson or the bank violated the vulnerable adult statute. I did a search. I couldn't find anywhere in the trial court level or in the opening brief where there was some assertion that court had this duty, and never was there mention of the vulnerable adult statute ever. So we think there's a clear waiver of those issues. Not to mention, I don't think that the position is supported by the law either, because there's never been any decision that I'm aware of that says that a trial court has a duty to act as an advocate and determine for you by holding an evidentiary hearing whether there's been some exploitation. But in this particular case, there weren't even allegations of exploitation, and at least none that were made. If any, I think my client would have made them, but never got to that point that had to make them.
Counsel, aren't there other channels to raise those types of concerns outside of the probate process?
Sure, and I'm not aware of it ever having been done by anyone. So, the court, the panel hit upon something else that I wanted to say, and I'm focusing mainly on things from the reply brief because you've read our answering brief. Saying that Mr. Simonson or the bank stole or were guilty of theft over and over and over does not make it true. The money that Ms. Negrete desired from the decedent stayed in the decedent's account. Mr. Simonson did not steal the money from his brother, as oft repeated in the reply brief. He just didn't. Nor did the bank, because the bank already was pursuant to an agreement with the decedent holding the money. There are no factual allegations, even taking them as true, that amount to conversion or theft. And frankly, I read the opening brief of the appellant to say it wasn't an error to dismiss all of the claims, all of the substantive claims. It was simply an error to dismiss them with prejudice because the court should have held an evidentiary hearing. So, but I really did want to emphasize that saying something is theft doesn't make it theft. And we don't have factual allegations that even remotely resemble theft. Does the court have any questions for me with regard to what the standards are for ousting a personal representative or appointing a special administrator? I mean, I think they're pretty clear in our brief, but okay. And I will pass to Merrill Lynch's counsel.
Thank you, Mrs. L. Mr. Maskovich?
Good morning. Jacob Maskovich for the Appellees, Merrill Lynch, Pierce, Finners, and Smith, Inc., Michael and Deborah Chen, and Bank of America, to the extent Bank of America is a party. I, to be honest with you, could not tell from the underlying pleadings whether that was ever intended or not. This case really, with respect to appellant's claims against what I'll call the Merrill Lynch defendants, if you will, honestly is admitted that the dismissal was appropriate. In the opening brief, page 3, appellant writes that for the sake of limiting the appeal and necessary arguments, saving fees for the parties, Zoschel doesn't appeal the claim for completed gift. Meaning Zoschel admits she had no rights under a completed gift theory to these funds, this $420,000. Sentence prior to that, Zoschel doesn't appeal the dismissal of wrongful dishonor, conversion, fraud, and breach of fiduciary duty claims. Those are the claims against my clients. Doesn't appeal them. So we're done. She says the only caveat is those claims shouldn't have been dismissed with prejudice. There's no briefing about why they shouldn't have been dismissed with prejudice, what arguments support a dismissal without prejudice. In this instance, where the appellant brought these claims against my clients in a civil action and it was dismissed, and then brought the identical claims against my clients in the probate proceeding in an amended petition. No additional facts.
It was dismissed in the civil action because of what was going on in the probate?
No, it was dismissed in the civil action after briefing, argument, and full briefing and argument ordered by the court. Dismissed.
With prejudice or without prejudice?
They were all dismissed with prejudice except for the court said you can replead fraud and conversion if you can do so with particularity with, under Rule 11. Go ahead. There were no that was never repled other than the identical same facts again.
But you wouldn't plead those claims in the probate action, would you? Isn't that more appropriate to, if they were going to plead those claims, to replead them in the civil action?
Procedurally, he filed an amended petition, appellant filed an amended petition in the civil action, in the probate action, then moved to consolidate. The amended petition in the probate court, though, Judge, just to be clear, included these same allegations, these same claims. Same claims in the civil action. So based on the pleadings, the admissions in the papers, there are no viable claims by appellant against the Merrill Lynch defendants. As I understand in the briefing, the argument is, well, if she was ever appointed, the appellant was ever appointed as the special administrator, then she could bring the claims. The appellant hasn't been appointed as a special administrator. She hasn't been appointed as the personal representative. The court was left with no option here but to dismiss these claims because there are no viable claims by the appellant in an individual capacity against my clients. She has no interest in the funds because she's admitted here it was never a completed gift. Okay, she had argued previously in the probate court that this envelope that the check was in somehow constituted a will or a holographic will, and the court rejected that a year or so before the court dismissed these claims. Okay. Now, there's been some conversation about whether or not it should be a hearing. And to be honest with you, the Merrill Lynch defendants, because the claims that the appellant has brought against us, she's admitted they're not viable at this time in individual capacity, haven't taken a strong position, but we have to be careful here what the statute says. The statute with respect to a special administrator is very clear. It's not just anyone that can bring a petition to appoint a special administrator. The hearing is only required if the petition is brought particularly by a person interested in the estate. That's a requirement. The person's not interested in the estate, the petition's inappropriate on its face. We never have to get to a hearing because the petition isn't brought by a, quote, interested party. An interested party is defined under the statute as somebody who has claim against the estate, as an heir, a divisee, a creditor of some fashion. But again, the admitted facts here are there was no completed gift. So the appellant is not an interested party under the estate, not interested in any fashion, is not a creditor. She has no claim against the estate, none whatsoever, based on the findings and the facts that have already been presented. So the court, and the court did, on the face of the petition. I'm sorry, Judge.
She would have a claim if the court inappropriately determined that it wasn't a holographic will, correct?
Correct. That's correct. Would have a claim as a desavee. But again, that claim, to be clear here, there's a lot of conversation about theft from the bank, et cetera. That claim would be against the estate for the $420,000. Even with the holographic will, has no claim against Merrill Lynch defendants whatsoever under any set of circumstances, which is what the court found. None. Again, and just to emphasize, the facts as they were pled, we accepted because it was a motion to dismiss standard that even if these are true, you have no claims against the Merrill Lynch defendants. That's what we accepted at the time. Facts don't establish any wrongdoing by Merrill Lynch under these legal theories at all, as the court has already found, and apparently as the appellant has now admitted in the opening brief. But to be clear, Merrill Lynch never stole these funds. Dishonored a check. The funds were still in the decedent's account. They dishonored it because of the $420,000 check to a payee the bank was unfamiliar with. Unable to get a hold of the decedent before they had to make a decision on the check, they did the appropriate thing and dishonored it. Okay. Funds were still there for the decedent. Never went anywhere. So we're still there the entire time. He had access, control, could do anything he wanted with them. I think the bank did exactly what you expect them to do. Okay, in this circumstance. I think we've all got that message from our financial institution along the lines of, did you just buy 7 iPads in Germany, right? And unless you affirmatively say yes, they do the right thing and they hold your funds. That's all that happened here. But again, even accepting all these allegations are true, appellant has no argument, no claim against the Merrill Lynch defendants under any set of circumstances. The appellant is not an interested party. She can't bring a petition for a special administrator by statute. even if we assume the allegations are true. Unless you have further questions.
Thank you, Mr. Markovich. Thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and the court stands in recess.